Hi everyone, I'm Jessica from 3PM and today I'll be talking about how to obtain an order of possession. First, we have the direct request process. Now, what exactly is the direct request process? It is an application for a dispute resolution hearing. The act allows for the hearing to be allowed in writing. The parties do not appear at the hearing and they do not contribute other than the landlord sending evidence. The tenant cannot participate in the process of applying for a direct request. If the tenant does not like the 10-day notice to end tenancy, if they file within 5 days, you cannot apply for a direct request. So let's assume you issued a 10-day notice to end tenancy. 5 days have gone by, you checked with the RTB, and the tenant has not filed to challenge the notice. So now you are going to apply for a direct request. A direct request is considered by an adjudicator, which is a junior arbitrator. They basically go down a checklist, and if they can check every box, you get your order of possession. But if they can't check one box, then you don't, or at least not immediately. You might either get a hearing or it will be dismissed to reapply. So basically it is a paper exercise. The adjudicator will not speak with you and you cannot explain the situation yourself. So make sure all the information is correct or your direct request will be dismissed. So when can you apply? You can apply the 6th day after the tenant receives the notice to end tenancy. A lot of people think that you have to wait the full 10 days, but the 10-day notice to end tenancy is basically a 5+5 notice. The tenant has 5 days to either pay the rent or file to challenge the notice. If they don't do either of those, they have another 5 days to move. So the tenant is supposed to be moved out by the 10th day. Check with the RTB on the 6th day and you can file for your direct request there. What are the potential results? So the potential results are you get your order of possession, you don't get your order of possession, your application gets dismissed with leave to reapply because you made a mistake that is not that serious, so you can just fix the problem and apply again, or your application gets dismissed without leave to reapply. And if your application does get dismissed without leave to reapply, you can just issue a 10-day notice next month and start over again. So make sure to read the decision carefully. So what is it? It is a written request for an order of possession with supporting documents. It is only available for unpaid rent and utilities in some cases. It is a streamlined process, so they just pass a piece of paper to the adjudicator and you should get your response pretty quickly, well, at least the first response. The application must be made online and a BCE ID is required, so a BC electronic ID. It is free and very easy to get. If you're applying online, it will show you where to get it. The adjudicator holds a written hearing, so it also has the same authority and effect as a participatory hearing. So before we continue, I just wanted to take a moment to introduce 3PM. We are a local property management company, and if you have any questions or you want to get to know a little more about us, or you're a property manager and you would like to join our team, please check out our website at www.3pmbc.com, which I will link in the description box down below. So let's assume 5 calendar days have passed since the notice to end tenancy was deemed received by the tenant and they have not filed to challenge the notice. The following must be submitted at the same time as the application for a dispute resolution by direct request. A copy of the tenancy agreement, a copy of the 10-day notice to end tenancy, proof on the RTB form that the notice to end tenancy was properly served. So we recommend serving it personally with a witness, posting it on the door if necessary, or by registered mail, which will delay the process. A direct request worksheet, which is a breakdown of the monetary claim, documents explaining any inconsistencies, which is the number one trap that people fall into. So if there are different renters from the tenancy agreement, For example, Bob and Carol are on the tenancy agreement, but it has changed to Charlie and Carol. You must have documents documenting this change. So whether it's an addendum to the tenancy agreement or a written agreement that is signed by everyone stating that Bob is out today and Charlie is in tomorrow. Or the owner has changed, or also the property management company has changed. So if the owner has sold the property to someone else, or the property management company has changed, you must also have documents explaining this. Next is all notices of rent increase, more or less than the current monthly rent is owed. So make sure to break down the total amount. So for example, rather than saying $2,000, you should explain $1,000 from last month, $1,000 from this month. So basically, you have to answer all possible questions that an adjudicator may come up with. So what is the process? The landlord serves a 10-day notice to end tenancy for unpaid rent or utilities. The renter pays all the rent in the first 5 days or files for a dispute resolution, which removes the option to apply for a direct request, or they move out. On the 6th day, the landlord submits an application for dispute resolution by direct request with all supporting documents. In person, if you can't do it online from a Service VC office, the clerk will submit it for you online on their computer. You can apply for an order of possession, unpaid rent, and filing fee, but please note that if the person lives welfare check to welfare check, there really is no point in filing for a monetary order. The RTV verifies that all documents are included and that no other active dispute resolutions exist on the unit. So for example, if you filed for an order to comply with the tenancy agreement to get rid of a dog, don't bother in applying. But you can cancel the existing one if you applied for it, but you cannot cancel it if the tenant was the one that applied for it. The RTV prepares a dispute resolution notice of proceeding package similar to notice of hearing package. The landlord usually receives it on the same day or the next day. Within 3 days after receiving it, the landlord serves a copy of the notice of proceeding package to the renter. It must be served in person or by mail, so it is best to serve it in person with a witness. The landlord will return the RTB proof of service online or at the Service VC office. An adjudicator reviews the documents and issues a decision. The decision can be grants an order of possession, grants an order of possession and monetary order and filing fee, refers the application to a participatory hearing, which will happen in a traditional way 4 to 6 weeks later, or they dismiss the application with or without leave to reapply. So what happens next? When an order of possession with or without a monetary order is granted, the RTB will email the decision and any applicable orders to the landlord. With a direct request, they do not email the tenant, so the landlord must serve a copy of the decision and any applicable orders to the tenants. It's different from participatory hearing because you must serve the order to the tenants. Personal or registered mail is recommended, but please do remember that with registered mail, it adds 5 days. You can post the order, but we do not recommend you do that because not every court accepts this method, so you shouldn't take that chance. But please do make sure to check with that specific court beforehand on what methods they accept. So some important parts: you can serve the notice to end tenancy by normal methods, but you must have solid proof of service such as Renter's or adult occupant signature showing received. The ideal is to have that person sign your copy of the notice to end tenancy, acknowledging that they've received it. Witness signature on the RTB form that was personally served. Picture of posting it on the door with the witness signature, which adds 3 days. But please remember to post 2 forms, one showing the front page and one showing the back, and to take a picture, as there has been cases where the adjudicators said that they didn't provide proof that the person knew what they can do when they receive the notice, which is on the backside. The backside is all the instructions, so make sure to provide proof that you did. So some important points. Remember to avoid irrelevant information, for example, served by son in proof of service. You do not need to list your relationship with the witness. You only need to include their age. Always request the order of possession to be emailed. This is faster and you can serve it immediately. This should be pretty automatic, but make sure to double check. The adjudicator speaks to no one, so leave no question unanswered. Review the application and documents objectively. Make sure it is 100% clear. The arbitrator has exclusive rights to the file, and the order of possession is valid forever. So there's no deadline, and you have 10 years to collect the monetary order.